Welcome back. Today's topic will be legal aspects in healthcare. Um, not too comprehensive today or too long, but it is, as I think you've already noticed, since we're pretty, I guess at least halfway there as far as content is concerned. Um, Law is a source of importance, not just to us as U.S. citizens, but obviously as healthcare practitioners. No matter which profession you go into, if you are dealing with humans, then certainly we have laws that aim to protect those individuals in a variety of ways. So, we've talked about a lot already as far as employment in the workplace and protection against discrimination with the ADA and such. So I don't have to rehash all of that, but as I presented those, it's probably a nice idea then to back it up with kind of how these come about. So like I said, certainly not a deep dive, but just a little bit more information to give you some expanded perspective about these legal aspects in healthcare. So when we talk about laws, and of course we're confining ourselves here to the United States, we have three sources, essentially. We have the Constitution, the judicial system, and then the federal and the state governments and their various agencies. Now, everything kind of shakes out, if you will, from the Constitution, but gets very, very complicated as we go along. So, constitutional law. The Constitution itself is considered the highest law in the country. It's pretty, it's open to interpretation, let's put it that way. So although it outlines the rights and responsibilities of the federal and the state government and individual rights and responsibilities, there are different ways to interpret that. And, it's pretty evident when, well, for instance, we'll talk about this later, but we have the Supreme Court, and it has 9 judges on the Supreme Court. And their job is to interpret and make decisions about constitutional law, typically. And when they do that, many of them come to different conclusions. Well, that, is probably a manifestation of experience, the things we've talked about, personal values, their political beliefs, and then how they approach these ethical dilemmas. Because a lot of times it goes all the way to the Supreme Court because things are ethically questionable, or at least it's an ethical dilemma, meaning of, if you remember this now, things are starting to come together, I hope you see. An ethical dilemma has to be controversial, meaning there has to be more than more than one viewpoint. So there has to be at least 2 viewpoints on a subject, and it should be a moral consideration. So something related to morality. So anyways, the Constitution itself, anything that's created is supposed to follow the Constitution. And what I mean by anything created, any new laws must comply with the Constitution. Then we have what we call common law. Common law can be set or is set by the judicial branch. So if you'll remember back from, high school civics or high school government class, we have our 3 branches of government. So we've got the executive branch, the executive branch being the president and his administration, the judicial branch, which is essentially the Supreme Court, and then all of its under courts, if you will, because there's actually several different district courts as well. And then the legislative branch, which includes our houses, so the House and the Senate. And that's all at the federal level. So then at the state level, it's very similar. So we have typically the governor of a state, we have the state legislature, and then we have state court systems. So very common setup. But we're talking here at the federal level or the national level. So anyways, common law if there is something that seems questionable or is not easily decided, and eventually it comes up to, let's just say, to the Supreme Court. But it doesn't have to be the Supreme Court. But let's say it does. The outcome of a court case can establish common law. Probably the most famous that is related to healthcare is Roe v. Wade. And this was a federal Supreme Court ruling, as I mentioned, that established common law right to privacy regarding reproductive rights for women. So oftentimes we talk about abortion when we talk about Roe v. Wade, and that's included in that. But there is, obviously, if you go look in the Constitution, there's nothing that explicitly says anything about reproductive health and or abortion. So what that means then is that we're left to interpret that, and we can then set common law if courts do so. And we can actually set common law also at the state level. So state laws can arise out of court cases in the state itself. So that's common law. So far we've got constitutional law and we've got common law that is established by court rulings. Administrative law then is when rules are set forth by agencies. Okay, so the federal government can create agencies and then give them the right to implement laws. The ones that are most common for us, although this is not an exhaustive list, but healthcare agencies in the federal government include the Food and Drug Administration, the FDA. These are the ones that approve drugs. So, all of our medications that go through FDA approval and and physicians are allowed to prescribe, then has gone through the FDA process. HIPAA is actually, so the HIPAA law comes out of the Office of Civil Rights, which, might not seem that apparent at first, but if you think about what HIPAA is, which is a protection law, and it protects your personal identifiable information and only allows information to go to people that you have said can see that information, then it makes some sense that it's in the Office of Civil Rights. And then overhousing a lot of different agencies is the Department of Health and Human Services, which includes the Centers for Disease Control, so the CDC. It includes the National Institutes of Health, the NIH, and so on and so forth. So there are lots of federal agencies that handle and implement laws. And these are just some really good examples, like I said. So you may be finding that maybe you aren't really, dealing with constitutional or common law a lot, but you're definitely dealing with administrative law. So we've got, let's just recap. Constitutional law, we've got common law, we've got administrative law, and now we have statutory law. And statutory law is probably the one you're most familiar with in terms of, like I said, when you were back in high school government class, this is when you have a bill. Or what was the Schoolhouse Rock had the song about creating a bill. So this is law created by federal or state governments, and they start as bills, which would be a document that outlines whatever topic it's talking about, and then approved and signed by both the Senate and the House of Representatives. Now at the federal level, this obviously then would be a federal law. But then if this happens at the state, it's a state law. And both happen. No matter which one you're talking about, they're still supposed to comply with the Constitution. But where it gets interesting, like I said earlier, is that the Constitution can be interpreted in a variety of ways, which then may allow ethical dilemmas to arise. So the statutory law is when bills get approved by the legislature, if you will. Governors and the president can also issue executive orders, and that happens. It happens, pretty regularly. I couldn't tell you the exact stats on presidents, but they all do this. And an executive order is when a president will issue a law without going through the bill process. So it's supposed to be something that doesn't happen too often. And I guess in terms of all the laws that we have, it doesn't happen very often, but you will hear about it fairly regularly because this is obviously it doesn't take that much time. The president or the governor can decide that something needs to be done. They can issue an executive order, and that's their right, and then that is law. Good examples of statutory law for us in healthcare are those Good Samaritan laws that we talked about. So just to recap, Good Samaritan laws are if you see an individual in distress and you are acting in good faith, that you are protected. So if something bad happens and for whatever reason legal action or legal questions come up on your actions, you're protected, you're acting in good faith. Someone was in distress and you tried to help. And then our mandatory reporting laws, remember those are those laws that require us in certain professions to report any kind of abuse that you suspect. And so most of you will be mandatory reporters because in education and in healthcare, almost all employees are mandatory reporters. So those both stem from the bill writing and approval process. Let's talk about statutory law a little bit deeper then, because you have actually two different types of actions. And so a criminal action would be this is very simply defined, but a criminal action would be considered a wrong against society. A criminal action would be obviously murder, driving under the influence, so you get a DUI, burglary, rape, so you have a wrong against society. A civil action is a wrong between individuals. And so actually, an action can be both civil and criminal. And I'll give you some examples of how that is here in a second, but they actually take place in two different types of court. A civil action, if you think about a civil action, the easiest way to explain this would be when someone sues another individual. So civil actions is there's a wrong between individuals. Wrongful death is a civil action where an individual, let's say a family member died and they were under medical care and they believe that family member died unnecessarily because of the action of the doctor. So the family can then bring against a wrongful death suit against the doctor or the hospital or all of them. So like I said, those are the easiest ways to explain this. Criminal action, there's a wrong against society, kind of includes all your big crimes, if you will. And civil actions are typically when you take legal action against someone, you sue somebody. But that, like I said, is the easiest way to explain it, not the exhaustive, comprehensive way to explain it. And yes, an action can be both criminal and civil. And criminal cases typically can, again, if someone is convicted of a crime, can result in confinement, probation, or community service, or some combination thereof. And if there's both types, then the criminal case typically will go first. So let's say an individual was driving drunk and they got in a car accident and a person in the car that they hit dies. That would be considered a criminal case, and it would be tried first. So that individual would be tried for DUI and Probably vehicular manslaughter, but it depends on what, again, the lawyers decide to do with that. And then whatever happens, happens. But the family of the person who died can then sue that individual who was driving under the influence for wrongful death. And typically, civil cases result in fines that are paid to either the victim or the family, depending on the situation, or it can be in order to perform specific actions. A real famous one recently was, if you'll remember, the recent case where there were two individuals who in Starbucks were arrested, and long story short, they were black. They were black males, and long story short, they settled out of court for a $1 settlement, and then Starbucks had to do diversity training. And if you remember that, all the Starbucks were closed for a period of time on a certain day. So that resulted in a $1 fine and an order to perform specific actions. So torts, again, I'm just going to mention a few of these things, and then I'm going to tell you, don't worry, how this applies to you, besides the fact, again, you're U.S. citizens and you're supposed to follow the law. But as healthcare professionals, I'll share with you a few real specific things that are important to you about this. Anyways, torts are wrongs against individuals. So intentional torts that are most common in healthcare include assault and battery. And this doesn't mean you are doing it. It could be against you as well. False imprisonment. So remember, someone can refuse health care. And if someone is deemed competent, then you cannot hold them against their will, even if you're concerned for their health. If they are deemed a competent adult, then they have the freedom to leave facilities. Defamation of character, invasion of privacy, that's a big one, and with HIPAA. Fraud and embezzlement is actually pretty common as well. I shouldn't say pretty common, semi-common in healthcare. So those are intentional torts. So those are things that are considered intentional, a wrong against an individual. Unintentional torts, so this is where this starts to become very applicable for healthcare professionals. Unintentional torts are known as negligence. Once a healthcare provider is licensed, and remember, depending on your career, you may or may not be licensed, but if you're a physical therapist, an occupational therapist, a physician, a nurse practitioner, a physician assistant, you are licensed through your state. And once you are licensed, then you can and will be held legally liable for employment actions, and you have to uphold standard of care. If you'll remember what standard of care is, it is that no matter the situation, you would give the same care to an individual regardless of situation, right? So no matter who they are, you're supposed to give them the appropriate standard of care. So unintentional torts are known as negligence. And often enough, healthcare providers may be sued for negligence. And this is a civil action. So this is a civil action. And negligence would then be, well, there has to be 4 components. So let's go through those first. So components to successfully claim unintentional torts or negligence is duty. So that means that underneath your scope of practice, you are supposed to do something. Okay, so you had a duty to do something and uphold a standard of care. There then has to be a breach of duty, which means that for whatever you're talking about, then you did not do that. You did not do your duty. Because of that, then, there has to be causation. So that whatever you did had to cause whatever happened. And then whatever happened had to have some damages, whatever that is, physical, mental, emotional, financial. So, you have to be the one that had the duty to act. You had to have breached that duty. You had to have caused something, and that cause should be something related to damages. Let me mention here that people can be sued for anything. Now I know that sounds really bad. It does sound really bad. That doesn't mean that there's a good case against you, but as a citizen of the United States, you absolutely can have a civil action brought against you for a variety of reasons. As a healthcare professional, you have lots of potential civil actions that could be brought against you. And that can be because, let me just give you an example. And I'm not trying to scare you because honestly, I have had very little, I've heard very little of this happening, but it does happen. I just mean personally, like friends and acquaintances and professional colleagues that I've worked with. This doesn't happen too often, but let's say you instructed someone to do something, they did it, let's say it's a squat, they hurt themselves. They can sue you for negligence. If you're a doctor and you hear about the crazy cases where, a doctor leaves a scalpel, in a person and sews them up during surgery, that would be malpractice. But there are a lot of malpractice suits that can be brought against physicians or nurse practitioners or physician's assistants, misdiagnosis, or other things that perhaps you did wrong, you were negligent. So anyways, civil suits can be brought against an individual for almost any reason. And as a healthcare professional, you absolutely need to be aware of that. As I said, I'm not trying to scare you, but you need to be prepared. So one way in which you can help yourself protect yourself, especially financially, from civil suits, is to have liability insurance. So in liability insurance it acts just like any other type of insurance, so car insurance or health insurance. You provide or you pay a premium a little bit each month, and in the event that you have a case brought against you, it protects you up to a certain amount, for legal fees and such, or lost wages. So this provides financial protection from claims that arise from clients who believe they've been a victim while under care, or there's been some wrong while they were under care. Almost all of you will need this in some form. So we have two different types overall. There are general liability policies that cover kind of a whole office, if you will, or a whole agency. And then there are personal liability policies that cover you as the professional. And although you have to pay for both, it might be a really good idea to have both, because what often happens is when somebody gets hurt or becomes ill and they believe they've been wronged, oftentimes people will sue not just the professional, but then also the place that they work. So a general liability policy covers usually all the employees within that organization, and a personal liability insurance policy would cover you as the person. Like I said, it's important. This doesn't happen often, but when it does, it can be devastating, especially financially. So it's really important to protect your assets, but also professional standing. You want to do things to keep your people as safe as possible, and there's lots of other ways to do that, but liability insurance is definitely going to protect you financially. So there's a lot of associations that actually offer liability insurance at discounted rates to their members, like ACSM and NSCA, so the National Strength and Conditioning Association, and IDEA. I did my liability insurance through them while I was doing wellness coaching years ago. So the IDEA Health and Fitness Association offers some discounted rates to their members as well. So you can purchase this. I don't hold this currently, so I couldn't tell you how much it costs. When I did have coverage many years ago, it was like $12 a month. So, yeah, $144 a year, but in the event that you get sued for something, that's really worth it. Obviously, I'm being a little biased here, but I want you to be protected. So you're getting that scope of practice idea. This scope of practice idea. Scope of practice is when you have a specific set of skills and knowledge that allow you to properly do your job. And it sets boundaries of what you can and cannot do. And we call those boundaries scope of practice. And I've mentioned this in a couple lectures ago, but a person really should only be performing duties specific to that job. When you start going outside of your scope of practice, you don't always get in trouble for it, but you could. You definitely could. And so you just want to be aware of what your scope of practice is and what you, for lack of a better term, are allowed to do, so that you really stay, you're the expert in that area anyway, so you don't want to go outside of that. But then also, if we're talking about protecting ourselves from legal action, then you definitely want to stay within your scope of practice. Like other text, or like other chapters in your textbook, we have another acronym, and the acronym is Python. So when we're thinking about protecting ourselves legally, the Python principle is protect yourself. So protecting yourself is obviously going to mean, in the real world, it's going to mean things like having proper training and certifications, and upholding your certifications so that they're valid and current. Doing your CPR and your AED training, when they're due. Hiring only certified professionals. If, so that's your choice, but that's a way you could protect yourself. Doing waivers, making sure that your equipment is working properly. I'm just brainstorming here. Keeping a incident log, so if someone does get hurt at your facility, you're writing down all the details, the paperwork, having them sign it, you sign it, so on and so forth. So there's lots of risk management things that you can do to protect yourself, but that's what the P and the Y are for. Think honestly. So thinking honestly is going to be, be aware of what's going on, but also quite honest. This is an acronym, right? So be honest with what's going on, and then observe naturally. And when you do this, you will protect yourself to a great degree. And it goes back to the other acronym, FLOAT, when you're talking about medical records, right? So if you're going to have medical records float, you want to be as objective as possible, but be retelling the facts. Right? So observe naturally. Protecting yourself, you're aware of the various ways you could be held liable, like I said, and making all of those different risk management changes. Honesty, building block in the foundation of ethics and trust, and then observing naturally, that keeping track, taking your clients into consideration, and being proactive when things happen. So like I said, when you do have an injury, doing a incident report, or putting signage on equipment that's not functioning properly. So doing all those proactive things to keep both yourself and your clients as protected as possible. So Python. Okay, so I hope that gave you a little bit more perspective into the legal aspects of healthcare, and how you, as a legal or as a health professional, kind of fall in to that system. So take care of yourselves, and I will see you back here soon.